Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Zadkovich of Zyla Floyd Zadkovich. How are you, Calum?
I'm good. I've rejoined after Joe stood in for me last week when I was on holiday.
Yeah, I'm sorry. I had to do one of these podcasts without you.
It's great, expanding the base, and I actually listened in. I saw I heard that he did a great job, so it was cool.
He did. I must say, it was hard to get in at times with Joe on the podcast. He's got a lot to say, a lot of good points to make. So I did enjoy it.
Exactly. That's the Joe we know.
That's the Joe we know. That sure is. Okay, okie doke. Well, today's case is a good one. I think you'll enjoy this one because it is one of the few cases to work its way through from the whole set of force majeure COVID-related issues to a court judgment. I'm not sure if there've been many of these.
Yeah, I've not seen many. And this is early COVID as well.
Yeah, exactly. Right at the start. It's interesting to see if this is the start of a string of these types of cases, but it really does shine the spotlight on those issues we were dealing with and our clients and colleagues were dealing with in those early days of the pandemic, trying to work out, well, if there's a force majeure event, is there a force majeure event? Do these facts, fall within the definitions of the force majeure clause? Can we terminate? Can we get out of contracts? Can we hold parties to contracts? You'll remember it well, but the advices were flying out left, right, and center on these types of issues at that time.
Yeah, and you know what strikes me most about this judgment is when you're in the teeth of it, as I think everyone in the industry was, 2 and a bit years ago, it feels almost like, how can this not be force majeure, right? Out there are world leaders on TV every couple of days, locking down major cities, major countries. It's this unprecedented. I remember people kept using that word in these unprecedented times, but it did feel unprecedented, and it did feel kind of like a living through history moment. And you almost felt at the time, surely this is what force majeure is all about. And when you go fast forward 2.5 years or so, and you see the way that the court is kind of dissecting the correspondence that went back and forth in a very cold, legal way, you realize the importance of kind of keeping a cool head at the time when something like this is happening. Yeah, as a legal advisor, obviously, for the commercial parties, they're saying, this is crazy, this must be force majeure. But really thinking, do we tick all the boxes that we need to tick in order to get force majeure? And will we still, if it feels like we do, then will we still do them in a kind of rational analysis in a courtroom 2 years from now when the energy of this moment has kind of passed by?
I think that is a very astute observation, if you don't mind me saying so, Calum, because I can remember back at that time, you and I having cases together where we would look at these issues, and it was almost surprising at that time how many of those advices went out where we were much more cautious about saying that this is a force majeure event, let alone a frustrating type event, than we may have thought. It's not to say there weren't some, and some I think were squarely in the FM and frustration camp, but there were quite a few, and this is a good case to highlight that, where you need to look really closely at what was the performance required under the contract, how was the force majeure clause drawn, what was in the clause itself, and was the event, if it fell within the FM list, was it actually preventing the performance? So look, with that intro, how about we get into it, just to give the case note. We're talking about the case of NKD Maritime as claimant and Bart Maritime as defendant. So refer to NKD and Balat. The decision was issued on the 24th of June 2022, so relatively recently. And it's a commercial court decision of England and Wales. And for those who like citations, it's 2022 EWH 1615 com, leading to big name leading QCs on the decision. It was heard by Mr. Justice Butcher, and the case involved a dispute over whether an agreement for the sale of a vessel that was being sold on for scrap, whether that was terminated validly or not in the context of COVID-19 lockdowns and related issues in India.
Yeah, so in this case, we had NKD were buying the vessel, essentially to then pass it on through to a scrapyard, and BART were the previous owners. So BART were the company who owned the vessel, and they were selling it for scrap. And the judgment quite helpfully actually sets out a large number of provisions, or a large proportion of the provisions in the MOA. So the judge kind of sets out the price provisions, the delivery provisions, obviously the FM provisions, the default provisions. So you can kind of see quite a lot. You get a good peek behind the curtain at the contract that they're dealing with in this judgment. But the key clause that was causing all of the issues was the force majeure provision, which spoke about the seller being unable to transfer title of the vessel due to force majeure events of some sort, and it sets out what those force majeure events are. Then essentially the sale is unwound, and the deposit, which was quite a large deposit, 30% deposit, would be refunded to the seller. Sorry, to the buyer.
Yeah, exactly. And that deposit amount can be topped up if there are further losses that are suffered by the seller. Yeah, and the force majeure clause, the exact wording on it was, should the seller be unable to transfer title of the vessel, or should the buyer be unable to accept transfer of the vessel, both in accordance with this contract, due to, and then the various force majeure events. And in many ways, it wasn't really contested that, it may have been debated, but I don't think it was a hot topic about whether the government lockdowns fell within restraint of governments, but that was what was the kind of operative part of the force majeure clause here, a restraint of governments. But the case didn't turn on that. The case turned on other issues.
Yeah, exactly. And effectively what happens here is this is all going through in March 2020 as COVID is blowing up across the world, and as we're starting to see lockdowns in all of the major economies, India being no exception. And the issue was that the vessel needed also, well, as COVID became an issue, the government mandated that certain certificates were required for vessels that were calling at Indian ports, or that were going to go into Indian waters, and the vessel was unable to get those, all the necessary certifications to arrive at the port that was the nominated place for delivery of the vessel. So there's some debate about whether or not, and we can come to this in a second, about whether or not the vessel gets to the customary waiting point at this port for delivery, or alternatively gets to the outer anchorage at that port for delivery, or alternatively gets to neither of those places and it's just somewhere else up the coast. But essentially the force majeure was relied upon in this instance by the owners of the ship to say, you can't sell us this vessel. You can't complete the sale of this vessel because we can't get the vessel to the delivery point, and therefore the sale can't be completed and it needs to be unwound.
Yeah. No, there are a couple of aspects to that. Whether there was you can't deliver it at the appropriate place as required, the delivery location, and therefore, because you can't deliver it, you can't transfer title. And then there was also the documentary elements as well, where NKT were arguing that the owners could not get certain certifications that were required to get the vessel into port and to complete the sale. And because they were unable to get those certificates, according to NKD, Bart could not transfer title. So there was, when when you're going to go through the facts of this case, there's quite a lot of detail around where the vessel could get to. Interestingly, there was evidence from captains, evidence from attorneys, Indian attorneys on the limits of the anchorage. There was some comments in there from the judge, but it was a really hot topic about what is the anchorage here for Alang? What's the Alang outer anchorage? Did the vessel get to there? And if it didn't get there, did it get close enough? And that was really, the two first issues dealt with by the judge were about that. Where did the vessel get to, and was it close enough?
And perhaps turning to that first question, which was the question of force majeure. One thing that I found quite interesting about this case, and about the case generally, and particularly this issue, is that a lot of the cases that we cover go quite in quite some detail into the law, and we've had a few recently in the last few weeks, particularly where the judgment almost reads as a textbook chapter on this is the law on how we deal with this specific issue, and they run through the tests and then they give you the tests. This case is nothing like that. It's pure construction and kind of impression of the judge of what these words mean in the context of the agreement. So it's kind of a break from the more dense, perhaps legal cases that we read, and this one's more just pure construction. How does Mr. Justice Butcher see that this contract should be read?
Yeah, and that did. I'm not sure I've landed on it. I'm sitting on the fence, but I'm not sure I've landed on my final view of it in terms of could it be up for appeal. But as I was reading it, it's very kind of similar observation to what you're making, but almost a slightly different perspective in that as I was reading, I was like, it reads very much like a first instance decision, right? Where the judge is having to grapple with the facts, or what facts are to be preferred, and sets all that out. And there's not as much law in there. And I just wonder, if you look at this decision, like in isolation, with the facts as found, and then come at it from a much more kind of legal analysis, whether there are aspects of this which you could kind of seek to appeal. It didn't, in terms of the ultimate decision and the reasoning for me, it didn't jump out as an appeal type case. But as you're describing it there, and kind of the emphasis on the facts and the lack of law really throughout it, as in case citations. I'm not saying there's a lack of law, but the depth of analysis of past decisions that we see in some of the other cases we've looked at recently, that wasn't really here. And maybe it just didn't need it to answer the questions that were really being put, because as you'll appreciate, Calum, force majeure is so fact specific, right?
Exactly, and it's so contract specific. And this is I think the other point to mention, that I think most of our listeners will know this straight off the bat. But what is the general English law concept of force majeure? Well, the answer is there isn't really one. It's just what the contract says. And I remember actually at the time when we were getting out our bulletins on force majeure around the time of these COVID, the first wave of COVID. I remember thinking, how do we say something useful about force majeure in an article form when every single force majeure is just the name of a provision under English law. There's no concept to force majeure. We can't just. How can we condense it into a 2-page bulletin? And the answer is you can just tell people you really need to read the contract, and that's I think what this judgment does. It's the judge really reading the contract, and as I said at the start, in the kind of cold forensic analysis to say, what does this clause actually say? And I think if you look at the clause, what does it actually talk about? It talks about an inability to transfer title of the vessel in accordance with this contract due to one of these things happening. And as is very often the case, the second part of that test is much easier to satisfy than the first, i.e., can we identify the existence of one of the listed force majeure events? Yes, normally that's not really the issue, because normally if you're questioning something about force majeure, it's because something has happened that you think is FM. You look at the clause, and it probably, it often is that's the bit you can satisfy. The bit which is harder to satisfy is then the second bit, which says that event has to stop you from doing a specific thing under the contract. And here that specific thing is transfer of title of the vessel. And I think that I mean, rightly, in my view, the judge drew a distinction, quite a clear line between transfer of title and getting the vessel to the delivery place or delivery of the ship. Those two
Yeah.
things were treated differently throughout. And the judge said that, there's no exception in clause 10 in the force majeure clause. The parties have specifically spoken about an inability to transfer title, not an inability to deliver the vessel. And the transfer of title didn't require the vessel to be delivered. So all of the issues in the world and are at the delivery place don't stop you from transferring title. And essentially, in a nutshell, the claim failed on that basis.
Yeah, and it was also a relatively narrowly drawn FM clause in that sense.
Yeah.
The FM events only really went to transfer of title, both the handing over of it and the receiving of it. But it wasn't a clause that said any obligations are suspended under the contract if one of these events happen, which is quite a common FM clause to see. Whereas here, it was very specifically focused on transfer of title in accordance with this contract. And the first question was all about construction of that. And as you say, the contract in other places differentiated between the concepts of delivery and the concepts of transfer of title. And because the contract had made that delineation in other places, that was significant in then assessing whether the sole reference to transfer of title in the FM clause meant that it was supposed to encompass delivery or not, and meant to just stand alone as its own concept. And I entirely agree that I think the judge has made the right decision there in the sense that the parties had intended FM to only apply with respect to transferring of title, not delivery. But then what the judge did is, because the judge kind of posed 4 questions to consider, it went on to say, well, if I'm wrong on that, I'm going to go on and answer the other questions before me.
Yeah. And I think just rounding off that, one thing that this reiterates is that you have to read the clause in the context of the agreement as a whole, and that's something that you learn it. It's very early in your law school. You'd learn that contractual interpretation is a process that takes into account the entirety of the contract. And actually, in this instance, the big clue that there was a difference between delivery and transfer and title was at clause 2A that spoke about the delivery location and expressly gave an option for delivery to take place somewhere that wasn't the delivery location. Sorry, for transfer of title to take place somewhere that wasn't the named, quote unquote delivery location, if there were reasons that meant that the nominated delivery location was inaccessible. So the parties had been very clear about there being a difference between delivery and transfer of title. They'd included the possibility for delivery to some place else to have the transfer of title. And then clause 10 just continued, force majeure clause 10 just continued that, that distinction. And the court found that none of these facts about force majeure, despite the fact there being all of these events that make it, difficult to impossible to get to the delivery location, although we'll come back to that, they don't affect the actual transfer of title of the asset. That just needs the bill of sale and a few other steps to be taken. So with that, essentially they'd make the determination.
Yeah, and there was language, there's express language in that clause, the 2A clause, that said that delivery at the other location would constitute full performance of the seller's obligations.
Yeah.
And that all other terms and conditions of the MOA would apply as if delivery had taken place. So the parties had really expressly provided for that in a way. But the takeaways for me from a construction perspective is, as you say, look at the contract as a whole, but different words have different meanings. And if parties are using some words in certain places and they're dropping other words in other places, that will be taken to have meant something, have been deliberate, unless there's, it's obvious that that's not the intention. But ordinarily, if you're trying to understand whether a concept falls within another concept, if they've been differentiated in other parts of the contract, then they'll be taken to be different concepts for the whole contract. But also this second aspect that we just talked about, where you also look at how clauses interact with each other, and you can get meaning from how the parties have set up other clauses with similar concepts to understand that concept and apply that understanding of the concept in a different part of the contract. And there's quite a few lessons in this on construction principles,
Yeah.
and how to apply them.
Yeah, absolutely. And then you go from the very heavy construction argument to the perhaps more factual question, which the judge looked at in real detail, despite having made a finding that that cut across the entire case. The judge then looks at this question of whether or not the vessel was actually delivered anyway. And this becomes quite interesting because there are a few parts to it. The first question is, did the sellers get the vessel to the anchorage? And they claimed they got to the outer anchorage. But if not, then did they get to the kind of customary waiting point? And this again turned on some small potential typographical errors in the clause. But I think, perhaps just dealing with the first question, did they get to the outer anchorage at this port? The answer to that was no, because they were a very, very long way away from it. And that to me seemed like quite a spurious argument. They effectively seemed to say that if they were, I think at some point they were about 200 nautical miles away from the port, which was about as close as they could get. But it's certainly not an outer anchorage, despite some attempts to persuade the court that it was.
Yeah, I thought that was optimistic.
Yeah, exactly. I think basically
it was nowhere near the port of Alang, apparently, and nonetheless, yeah, they were arguing. I thought the other interesting aspect, or the few interesting aspects about this, but the debate about whether the ship was an arrived ship, which is a concept that we know quite well in our context, which is really the context we're talking about here, was a vessel in a place where it could tender NOR, had it arrived. And I found it interesting how Judge here didn't go into a lot of the law on arrived ships and what that meant. There wasn't 4 or 5 paragraphs setting out what arrived means in the broader NOR context. But I think that the way that it was interpreted here was to say, you've got to bring in the concept of as near as the vessel can get, as close to the delivery location as the vessel can get, in understanding this, and that when you're looking at it through that lens, this vessel did get as close as it could, and that there may be cases where the vessel's so far away that it couldn't be considered, for the purposes of a clause like this, to be arrived, in that it's gotten to the edge of the limit of where it can get to here. It could be very, very far away, and there is some imaginary line. I don't know where that is, but it was, I thought that was, if you like, maybe one of the areas, or the legal areas of this judgment, which wasn't as crystal clear as some of the other points.
Yeah,
I was interested to know what you thought about that.
So what jumped out to me on this, I don't think there's anything. I don't think that this is in any way an inaccuracy in the judgment. It's just sometimes the way that the dice fall on these kind of issues is that you had one party saying there's this FM event that means that you can't get near to where you said you're going to deliver the ship, so we've got to unwind everything. And the judge basically said, no, the FM event doesn't really make a big difference in that context, and therefore the sale has to go ahead. And then the other party says, well, actually, we tried to get as close as we could to the delivery point, but because of the same FM event, or because of the same events, the same underlying event, which the other party is relying on to try and claim FM, because of those same events, we actually couldn't get any closer. And the judge kind of goes, yeah, fair enough. You did your best. You couldn't get any closer than that because everything was going crazy. It almost feels as though it's like on the one hand, for the party that's trying to rely on force majeure, they're saying no, listen, you can't rely on that. And then for the party who's not trying to rely on force majeure, they're getting a bit of extra leeway because they just had no option but to park the vessel there. And I don't think there's anything. I don't think there's anything wrong in the decision about that. I think it's extremely legally coherent, and it makes absolute sense when you read all the clauses, and that's the bargain the parties struck at the end of the day, and the courts are there to make sure that bargain is adhered to. But it did feel a little bit like if you were on for the party that ultimately lost this case, you would be thinking, oh yeah, come on. On the one hand, we get told that RFM's not good enough, and on the other hand, they get told that they've delivered the vessel, even though it's 200 nautical miles or so away from the delivery port, because they've got as close as they can and they're waiting there.
Yeah. Yeah. As I say, that's the area I'd be. That if the case only turned on that point, then I'd think, yeah, I'd look more at what arrival means in this clause.
Yeah.
And how it interacts with the FM, but they've got the other points against them as well.
Yeah, and I actually think the other points are stronger. I think that
I think the other points are stronger. I think the first point is I don't see that being turned around. I'll probably eat my words one day, but I just don't see how that gets turned around. In the construction point is wrong. Anyway, so yeah, any other comments you had on that second question about?
There was one. There's one other point which I think is something that will be attractive to the pedant that lives within every lawyer. I'm trying to just flick through the judgment to see, but it was what looked like a missed S, and in the clause where it was talking about essentially what the judge was looking at here is they were saying, well, occasionally, very very rarely, vessels do wait for the named delivery location in the place where the vessel ultimately had to wait because of all of the issues that were going on with COVID. But it's not the kind of normal customary place for vessels to wait for that port. But the clause, the delivery clause, talks about if the buyer fails to nominate such place, that bit's not relevant. The place at which it is customary for vessel to wait shall constitute the delivery location. And the judge talked about whether that was a typo, and it was actually meant to say the place at which it is customary for vessels to wait shall constitute the delivery location. In which case, there may have been some more difficulty here, saying, well, we got the ship to somewhere where, feasibly a vessel can wait, but vessels do not normally wait at this customary place. Or did the parties actually mean to use the singular rather than the plural? And if they intended to mean the singular rather than the plural, then the clause says the place at which it is customary for vessel to wait shall constitute the delivery location. And the judge kind of said, effectively, I can't just find that it's a typo. I have to give at least some weight to the idea that this is what you intended. And if that is what you intended, then it makes more sense to say that you're basically, the parties are agreeing that if you can get the ship to somewhere where it makes sense for the ship to wait until it can pass through whatever it needs to pass through, get whatever documents or pass the administrative hurdles that it needs to pass before going into the port, then that satisfies this, what seems like a perhaps wider, a slightly wider net if you're looking at vessel rather than vessels. And I think that just is, to me, it looks like it's obviously a typo, but you don't, when you're dissecting these contracts in front of the court, then they don't just simply go, that's a typo. They will take the contract at face value. So it's always worth that second, third, fourth proofread to make sure that you're saying exactly what you want in these contracts.
Yeah. I struggle a little bit with it. I've got to say it's clearly a typo, I think, and I say that because the word customary, well, I suppose you could argue it both ways. The word customary would ordinarily denote something happening to multiple vessels or multiple occasions or instances where it's not just, it's a word you tend to use not just about the one vessel, but about what happens in other instances. Now that could be, a retrospective or prospective. It could be looking, what is customary moving forward in those circumstances, and that's kind of where the judge is taking with the singular, rather than what do multiple vessels typically do over years gone by. And I think the judge was reluctant to do that because that would be effectively inserting an S into the clause that's not there. So customary was understood to mean more like normal, like what would be customary for this vessel getting there to do using, good seamanship and navigation, what have you. I don't know. It felt like a bit of a side point, but it's worth noting. It reminds me of the, what's that case? The Zenobia case, where you had an arbitrator that ruled that WP in a redelivery notice meant, might get this wrong, but meant without prejudice rather than whether permitting. And, anyone in the industry would have thought, well, only a WP in that context with all the others that, UOC and WOG and the others probably meant whether permitting, not without prejudice. But it wasn't clear. And then the courts were stuck with the factual finding of the arbitrators, and courts pay deference to what are the words that are actually used, even if they're typos. And if in that case, arbitrators had ruled factually what certain abbreviations meant, and then they get stuck with it. It's just it's a drafting point, isn't it? You've got to be clear. You've got to always be checking that contract. Otherwise, you can end up with some unusual results. Here, it didn't really matter.
Yeah, I mean, it was
at the end of the day.
It was one of the kind of ancillary points to one of the ancillary points. The one thing that did make me chuckle is when I was going back through the clauses as they were presented in the judgment. This part of the delivery clause says the place at which it is customary for a vessel, and then it has in brackets sick to kind of identify that that's thought of as a typo. But then actually later on in the judgment, they say, no, it's not a typo.
Yeah, exactly. I saw that. So, well, look, we're doing our usual, get into some case and just keep going on and on and on. We probably should move along a little bit. Should we jump over to the third point?
Yeah.
So essentially part one on the first two. So they're on fire, the owners of the ship. They didn't need this last point, but the judge went on to decide it anyway. And in some ways, I think this is perhaps the most interesting question when looking at COVID-19 lockdown, government ruling type cases in a force majeure context. Yeah. And so, this third question was all about whether the government decisions or the lockdowns on certain departments of the government that prevented or hindered key issue certificates being issued in time for the owners to perform all their obligations on the contract, whether those fell within the force majeure clause such that transfer of title could not be completed. And so, what the judge did in looking at this question was go through, again, in a lot of detail to assess what were the certificates or approvals that the vessel was supposed to receive. And there's a lot of evidence on this from experts, from factual witnesses, on what were the processes within the government to issue these certificates, what were the various government decisions and orders at any given time. There was a legal question in there about whether the clause, to activate the clause, whether the government decision had to create an inability to get the certificate or just a hindrance or a delay to the certificate.
And I think that's
I thought that was an interesting point.
I agree with you. I think that's because that's something that you see a lot in different contexts. And I think, so that say for example, you are looking at a charter party, a standard form charter party that's the kind of house form for a major chartering company or a major ship owner. They will have, presumably some quite broad rights that allow them off the hook if they have things like hindrance or delay. Whereas in this particular contract, the word was inability, and the judge talks about how inability. The judge says that the criterion was not hindered or delayed or the like. Inability means something more than that. It doesn't mean that you're hindered in doing something. It means that you're unable to do that thing. And they looked at that in the context of the limited time to effect the transfer of title, and they said, well, if inability meant if it satisfied the inability threshold that you were delayed from doing something until the expiry of the period in which you said that you were going to do it contractually, then that could have the effect of essentially meaning that a delay is elevated to an inability. And they kind of kicked that idea around a little bit to see, how basically how much difficulty had to be imposed by the by the factual circumstances in which the party was trying to rely on that clause. It's an interesting one because
Yeah. Yeah. It was also this, there was a debate about that because, if inability just meant hindrance, then, as it was put by Mr. Young QC for Ballot for the owners, that could potentially pull in, very short-lived and transient type hindrances. And that's not really what this clause 10 force majeure clause was aimed at. And I thought there was something to that. And the judge also went on to look at, what kind of inabilities would materially undermine the commercial adventure. And that was a phrase that he used, and relying on a relatively recent case, the Ed Winton case in 2007, when putting forward the principle that these things shouldn't be looked at just in isolation. You need to look at what are the parties actually intending by this clause? What is the commercial advantage? Does it make sense to have small hindrances being triggered by this force majeure event, particularly when the whole clause is about the fundamental obligation of transferring title? And as you say, when the hindrance means that you can't perform at all within a certain time frame, well, okay, that may be triggering, but hindrance in itself doesn't kind of equate to an inability. Was ultimately what was the decision here on that point.
yeah,
The other area though is the factual points around what was the actual state of the lockdown, and what was the order that had been made. And here they looked at the various orders on the government departments that had to issue these certificates, and they were like work from home orders, or they were prioritizing other work over this type of certificate. So it wasn't like that there was an order that had come out that had targeted these types of certificates and said, these types of certificates will not be issued for the next month or two. There was some kind of broad ship breaking lockdown for a while, but it wasn't really targeted. It was only for a short period of time, and you could, in theory, still get this certificate or certificates. It just may take a bit longer.
Yeah, and when you put that in the context of the shipbreaking process for a ship of this size, then actually the delays weren't a massive percentage of the amount of time that this process would have taken anyway to demolish the ship.
Yeah, well, the judge made the point that to beach the ship at this location, there's, I think, 2 points in a month where the tide is just right to get the vessel up on, on board on ashore on the beach. And so if you miss your tide, you could end up waiting a month.
Yeah, exactly.
And in that context, that's what I'm trying to say about the commercial adventure, what was actually happening here. It's not just not looking at a clause in isolation. In these FM cases, you're looking at the facts, you're looking at all of it. And it really ties it back to where we started on this podcast, that for these force majeure cases, and we've seen it again in with what's continuing to happen over in Ukraine, which is just terrible. And we'll try not to get into that again on another episode, but with events that are playing out in real time, with heightened emotions, with concern, quite rightly, the court ultimately looking at that in a year or two down the track is going to be looking at, what does the clause do? What were the actual orders? What was being prevented? Was that what the parties had contemplated in their commercial bargain? And these factors so when you're advising in real time, in amongst the emotion, you've got to try and strip it back and look really closely at what's going on.
Yeah, I totally agree.
So I know we've probably got other things to say on the case, but I feel like we've probably covered some good territory there, Cal. Any other final parting remarks?
No, I feel like we've bookended it quite well. We've kind of come back to where we started, so that's quite a neat place for us to draw the line.
And for those wondering whether Bart managed to get more than the deposit or not, they didn't. They didn't have enough damages to get over the 4 odd million that they managed to pocket on the deposit. So
Yeah,
that's what they got.
I think they'll be happy with that, to be honest.
I think you're right. On that note, thank you all for listening in. We hope you've enjoyed this one. It's been a hot topic for 2 or 3 years now in many ways, and this is a good case to read if you've got a case in that territory, and really pulls it all together in a great way. Thanks for listening. Please do like our content, follow us on Spotify and Apple Podcasts. It really helps get our message out there, and we're grateful for your patronage. Till next time, take care. See you, Calum.
Cheers, everybody. See you, Luke.